Our next panel is Why Arbitrate? And we have moderating our very own Dancia Penn OBE QC, who we all know is the managing partner at Dancia Penn & Co. From New York is Natalie Reid, who's a partner at Debevoise and Plimpton. Calvin Hamilton, who's a senior lecturer at the Faculty of Law at the University of West Indies in Barbados. And Carita Wallgren Lindholm, the founding partner of Lindholm Wallgren Attorneys Limited, all the way from Helsinki, Finland. Carita actually, I would say, was coming from Anguilla, where she resides some of the time, but she was unable to be here with us in person today, but agreed to be here by video link. So welcome, moderator and panelists, and I will hand over to you.
Thank you very much, Dawn, and a very pleasant good morning to everyone. I would like to begin by thanking Russell and Dawn and all the organizers of this very important conference for inviting me to be here and to chair this panel. I would also like to compliment them and the entire government on all that is being done and all that has been done to bring us to this place today. And my own honest opinion is that we have a very bright, though challenging future ahead in this area. I'm honored to have two very distinguished colleagues physically present and by video link, our distinguished colleague, Carita. Each of them will tell you a little bit about the areas, about themselves and their practice areas and their interests very briefly, because we hope to maximize well this hour that we have. We thought, after discussion, that it is very important that we know and understand what we are speaking about. And after each of them has introduced themselves very briefly, Calvin, who is to my immediate right, will, for the benefit of all of us, and to put today and the deliberations of today in its fullest context, answer that very simple question: what is arbitration? We think that, and to some of us, it will be a bit repetitive, and we know what it is. But many of us, I know, do not know. And as lawyers, we all know how sometimes we pretend to our clients and to our colleagues and so on that we understand concepts that we jolly well know we don't. And I had a mother who always said to us, ask even your stupidest question. So we're not going to leave it to you to ask the question. We will have Calvin tell us a little bit about the basic thing of what is arbitration. Having done that, we will then move on to discuss, and we want to invite your participation and invite your participation very strongly. We will discuss why arbitrate. So thank you very much, and would you, Natalie, introduce yourself, tell the body a little bit about yourself, then Calvin, and we'll move on. Thank you.
Absolutely. Thank you very much.
And Carita, you, of course. Welcome. We know, we know you're on a very different time zone, but we are grateful to you for taking the time. Good morning to you. Thank you very much.
Thank you very much, Dancia. So very briefly, as Dawn and Dancia mentioned, I am a partner in the New York office of Debevoise and Plimpton. I have the great privilege of practicing with Lord Goldsmith and others in the field. I'm originally, I still am, Jamaican. So trust me, there are times when I lose sight of that, but when I come back to climates like this, it is very much at the forefront of my mind. So in terms of our practice, it is as broad and deep as one might expect. It is a truly international dispute resolution practice, so international arbitration is at the core of it, both commercial and treaty arbitration, public international law, and complex commercial international litigation.
Hi, good morning. Protocol having been established, I'll suffice it to say thank you for the invitation, and I'm happy to be here. Like Natalie, I'm from region. I'm from Guyana originally, though I've honed my skills for the last 30 years in Spain. I'm admitted to practice in New York and in Spain, and I used to be a transactions lawyer, and the last maybe 15 or 20 years or so, I've become involved in arbitration. I've had the good privilege of studying arbitration and being taught and tutored by one of the foremost practitioners in the world today, a fellow by the name of Bernardo Cremades. And at Bernardo's elbow, I was able to see how arbitration actually developed. A lot of the concepts that we take for granted, I actually sat in the room. I carried his bag, so I was able to sit in the room and see how the discussions developed with respect to a lot of the concepts that we take for granted today. I worked for two of the major law firms in Spain, international law firms. I set up my own firm after, in 2008. I still have it. I'm able to teach at the faculty and continue to manage arbitration matters for my firm. So I'm happy to, for the UE folks to understand the need for me to continue to be involved in the area, and I'm happy that my partners would tolerate my long absences from the firm. Arbitration is an interesting beast, and there are a lot of war stories that I can tell to make it even more colorful and let you understand how arbitration is developed, but I'll leave that for later. But suffice it to say that I'm an arbitration practitioner, been doing this for the last 30 years or so, and happy to impart some of the knowledge that I've accumulated over the years.
Thank you very much, Calvin. The UE of which Calvin spoke so affectionately and naturally is the University of the West Indies, which is the alma mater of many of us in this room, our distinguished Chief Justice, Dame Janice, Mr. Ferrara QC, Paul Webster, many, many of the lawyers practicing here. I just wanted to clarify that. We speak of it affectionately as UE, but it's the University of the West Indies. Carita, welcome. And
yes. Apologies for not being there in person. Is the audibility okay? Can you hear me?
Perfectly well. Can everybody hear her?
Yes.
Thank you.
Thank you. Thank you. I am a civil lawyer. As you will understand, I reside in Finland. And having spent a few decades in a big law firm, doing counsel and arbitrator work, I, as warranted by my age, today I'm in a boutique law firm on my own and only as an arbitrator, mainly in Europe, but also outside of Europe. I started my career in arbitration in Paris at the end of the 1970s, and now reside, as I said, in Helsinki. I do mainly commercial arbitration, but also some investment arbitration as counsel and arbitrator. Thank you.
Thank you very much, Carita. And I think it's important that the audience knows that you also have a connection in the region, in Anguilla, and that
yes. Since about 10 years, I live there part-time, which is probably the reason for the kind invitation for me to participate, albeit virtually. Thank you.
We welcome you, and we know that you will bring a broad and interesting perspective. Thank you very much. Calvin now will tell us a little about what arbitration means. What is arbitration? Calvin?
How many of you have been involved in an arbitration?
Could we get the hands a little higher?
Okay. How many of you are lawyers? How many of you are transactions lawyers? How many of you have gone to one of your partners at the 11th hour and say, give me a clause, we're going to include an arbitration clause?
Oh, be honest.
Not one.
Not one of you?
No, not one.
All right. My experience is that that happens often. And when that happens, it's a recipe for disaster. Because the person providing that clause does not understand what the transaction is about. There's no time to explain properly what the transaction is about, and as a result, you can't tailor the arbitration clause to suit the transaction and anticipate where the problems will lie. And I throw that out at you to have you think about that as we go through the discussion. Arbitration is an alternative to the national courts. When I say alternative to the national courts, I do not anticipate that the national courts will not be involved at all in arbitration. They're the protectors of the integrity of the arbitration process. They're the final arbiters of what happens in an arbitration. So also keep that in mind. The exclusion of the national courts, it's a private mechanism for dispute resolution. In other words, the parties decided for A, B, or C reasons, they would like a process that's specifically tailored to their dispute and their business practices. It might well be that they're from different nationalities and jurisdictions, and as a result, they are less reluctant or reluctant to go to the jurisdictions of either one of the parties, so they select this process to do that. It jumps out at you then, it's controlled, selected and controlled by the parties, which provides an additional comfort level for arbitration and people involved in arbitration. And last but certainly not least, it's final and binding. So hold those four thoughts. First, it's an alternative to the national courts, it's a private mechanism for dispute resolution, it's controlled by the parties, and it's final and binding. Now just think of two companies, German company GHMB and BVI company get involved in the transactions. Companies A, the German company, company B, the BVI company. And you've got a dispute, it's a commercial dispute, and a dispute arises, or a commercial contract, the dispute arises. Start to think about the complexities of resolving that dispute. Start with, should we litigate in the BVI? Should we go to Germany? There is no international court of justice, so to speak, for international commercial disputes. The other thing about arbitration is that there's a framework. There's a legislative framework in place which includes conventions and includes international instruments that support this process. So there, in arbitration, that's what we have to work with. So I'll stop there with respect to what is arbitration. It's those things. We'll get into the ingredients, the arbitration clause. We'll get into the different laws that could apply. We'll get into the award itself. We'll get into the procedural. We'll get into the recognition and enforcement of that award. But the international instruments that I've just outlined will help us to get there.
Thank you very much, Calvin. And please bear what he said in mind, and we will have a chance very shortly for you to participate in that and for us to flesh that out even more. Natalie?
No, on this point, I entirely agree with what Calvin has outlined. The key things, I suppose, to remember, particularly if you're dealing with a commercially sophisticated jurisdiction with a very well-regarded judiciary like you have in BVI, and this is anticipating, I think, a little bit some of the questions, sort of why arbitration? Because some of your clients, if you propose an arbitration clause, will ask, well, what's wrong with the courts? Why is it that I would want to be in arbitration? One of the points that Calvin mentioned is often brought up, which is if you have sort of cross-border transactions, even between very sophisticated parties, they often don't want to find themselves in the courts of the other party's jurisdiction. This is, sort of the home court advantage. Where you have courts that are well regarded, that concern might be mitigated, but you still have, I think, the two key points that Calvin also touched on, which is privacy of the proceedings. There's the key point about confidentiality of international commercial arbitration. And what you have, I think, also here in the BVI, when you have a truly arbitration-friendly legal framework. So in the new Act, there are provisions which not only recognize the confidentiality of the proceedings themselves, but also to protect that confidentiality will have similar provisions to ensure that when you have related court proceedings, for example, that you don't inadvertently sort of disclose things that would undermine the confidentiality of the proceedings. Because as we all know, in ongoing business relationships, there are reasons why you might not want to have a dispute subject to the glare of sort of public attention, public misunderstandings that you might have if you were in court. So that's the first point. And the second point is the enforcement point that Calvin also touched on. BVI, as now a party to the New York Convention, so this is the global convention for the recognition and enforcement of arbitral awards, means that when you have an award that is rendered in BVI, it will be enforceable in a host. I think the number, I should know this, it's 125.
45 or 45?
No, it's more.
159. Thank you very much. My colleagues are looking at me askance because I should know that number. But, 159 other jurisdictions around the world, including those in which you are most likely to find the assets against which you want to enforce, and is subject to challenge in those jurisdictions on very narrow grounds. So that will be a key distinction between the arbitration award and a judgment, even from a well-regarded court. And those are, again, sort of the key things that you would want to keep in mind, because as, again, sort of experienced counsel, when your clients will look to you for this advice, one of the, sort of the points that you would have to respond as an advocate and as a counselor will be, what is it that I gain through arbitration that I would not have through litigation?
Mm-hmm. Thank you very much. Carita?
I could add that I come from a part of the world where actually the question may not be asked so frequently as to why arbitration, because arbitration was very much, and I mean arbitration in the form we discuss arbitration now, the traditional way of resolving commercial disputes already when I grew up, and the courts are very arbitration friendly, and I would say that arbitration is so prevalent and has been to the point that sometimes we could almost find a scarcity of legal precedent from the courts because most disputes have always gone on and still continue to go to arbitration.
That's extremely interesting, and I believe it is one of the areas where, and several of us, because Lord Goldsmith last night, Justice Leon this morning, our Chief Justice and our Premier, I think they all essentially in their words, indicated the fact that culturally we would need to become more attuned to arbitration. So that's one important difference, I think, between what you grew up experiencing, Carita, and the position of us here in BVI and, in fact, in the Caribbean region. Mm-hmm. Is there, which of you would like to say a little more? Calvin, would you like to now go a little more into the main topic? Why arbitrate? In a way, we've already given some of the answers, but I know you want to speak more substantively to that.
Yeah, there are a number of issues, and again, because of the time factor, we'll have to sort of run along. There's the perception of national prejudice for a particular jurisdiction. I think you touched on that. The judges that would hear your dispute in an international context tend to come from either one jurisdiction or the other, because you wouldn't have litigation in London if the parties are from the BVI in Germany. The British courts will say, well, why are you here, kind of thing. Having said that, there are sophisticated reasons why maybe sometimes that could work. But the lack of knowledge of the international dispute of the judges in the local jurisdictions is one of the other reasons why you might want to consider arbitration over litigation. On arbitration, you get to pick your arbitrators. You get to pick people who are qualified and understand the dispute. Not that your arbitrator is going to be your advocate on the panel, and be careful about that, because the tendency to pick your cousin to represent your interests on the tribunal is a no-no. And one of the reasons that's a no-no, it's a very practical approach, because it's a human thing. And what happens is, if the other arbitrators perceive that you have a particular bias, then of course you discredit yourself within the tribunal, and that collegiate atmosphere that you try to create. And having discredited yourself with respect to the other two arbitrators, now I talk in the context of a three-arbitration panel, you actually do your client, in inverted commas, a disservice, because your points of view will not be properly heard at the tribunal level. So you want to be able to pick somebody who is knowledgeable, somebody who is impartial, somebody who has and can represent the interests of an arbitration process properly and judiciously. In litigation, it's open to the public. We don't want that. If you're a high-tech company and you've got a lot of patents and you've got a lot of interesting materials that you don't want in the public domain, as Natalie pointed out. The rigidity of the court procedure is something that's not necessarily so in arbitration. There's more flexibility. The arbitrators tend to be much more understanding with respect to procedure, with respect to terms, and these sorts of things, within reason, obviously. It's the ease of enforcement that we talk about. It's the neutrality concept. It's the confidentiality. So all those reasons are present why we would want to arbitrate, and you don't have that present necessarily in the national jurisdictions. And I'll let the others pick up.
I've already touched on it. I'm not sure if Carita wanted to add.
Well, we have a question. Many of you, it's in your program. The question is this, and I'd like the response of each of our panelists. Can lawyers in the Caribbean region be dispute resolution lawyers effectively handling both litigation and arbitration? Carita?
I'm happy to address that with the limitations, obviously, of not probably being fully conversant with all aspects of the region. I would say this, first, a sort of a cultural point and a soft point. My experience in the region is such that there is a cultural open-mindedness also in terms of law that I think is very prone to be well versed in international dispute resolution, where obviously there are international best practices or almost best practices that practitioners adhere to. I think that, like people from my region, you probably would go somewhere to get some additional education in the field of arbitration, but I do think that it is probably not particularly challenging to, if you take your time, to become a good arbitral lawyer as well as a litigation lawyer. I think personally, being of the age group where most people came to arbitration from international private law, I believe that it's a great addition to an arbitration practitioner to have a litigation background. And I think especially sitting as an arbitrator, I think that the decision-making, the case management is greatly supported by the fact that you are used to thinking in terms of litigation. So I think that the region as such and the practitioners there, to my understanding, have a great platform to also enter the world of international arbitration. There is another aspect of this which I will not now sort of hijack the floor with, but which I think is a very interesting aspect of this is obviously law firm strategy in this respect, because I think that is a challenging area, the extent to which the big law firms support their practitioners also to become arbitrators, which often is not completely aligned with the leveraging of a big law firm. But I will address that to the extent you, Mrs. Chairman, think that we have time towards the end. Thank you.
Thank you very much. Very interesting comments. Natalie?
So if the question is, sort of can counsel in the BVI specifically in the West Indies be arbitration practitioners as well as litigators? I mean, the answer is absolutely yes. Clients look for the same things in their arbitration counsel as they do in their litigators, and the BVI bar is extremely well poised to deliver that. It is counsel who are sophisticated, who are commercially savvy, who understand the playing field and the rules of the game, and can, within those rules and taking advantage of that savviness and that experience, craft solutions, provide advice, provide counsel that is tailored to, that meets and anticipates the needs of your clients and further their goals. Now, folks, practitioners from jurisdictions outside of the West Indies have no monopoly on those skills and that experience. What arbitration brings, I think, is a new context, a new vocabulary, a new rubric in which all of those skills will be deployed. And I think, particularly given the great significance and continuing support that you will have from folks like Don Smith and the Financial Services Commission, from the judiciary, from the government, these are, that sort of vocabulary, rubric, skills, etc., that is easily learned. And the question is, therefore, how do you deploy it through all of the various, sort of phases of the arbitral process? As Calvin had touched on, there are a number, in many ways, sort of the key defining feature of arbitration is that it is party-driven. There is incredible procedural flexibility, and therefore there is incredible power in the hands of clients and their counsel to design that process, to tailor that process from the arbitration clause, where you should call your arbitration counsel before the 11th hour, and all the way through the very key points. Picking your arbitrators, for example, will almost more than anything else shape the process, the experience of arbitrating, and will guarantee the result. You might not necessarily, because there will always be a losing party, but with experienced arbitrators, you can actually accomplish the goals that people go to arbitration to seek. An efficient process, a fair process, in which people are able to present their cases. They feel that they have been heard. You have arbitrators who are as experienced, not just in providing, adjudicating that dispute, but understand the very nature and the distinctive features of international arbitration. So will aid the parties in getting to that resolution and in crafting an award that is enforceable. Now, the role that counsel plays in all of this, and I'll pause because I know I've been going on for some time, is crucial. It is everything from not just having an off-the-shelf arbitration clause, from understanding the particular challenges that your clients will have, not just as an entity, but in the context of different commercial relationships in different jurisdictions with different counterparties, and very sort of strategic decisions that are made at every step in the process, including at what point do you seek the assistance of courts in which jurisdiction? Do you go for a fast-track arbitration? Do you go for a slower-paced one? All of these are the exact kind of tactical decisions that clients are used to making in litigation and will look to counsel to guide them with in the arbitral process as well.
Thank you, Natalie. Now, I know that Calvin wants to add to that as well, but before he adds to that, I look at the corollary question on our program. What skill sets and mindsets are required for success as a lawyer in arbitration? Calvin is very well qualified to speak to that.
I don't know about that, but I'll say this. There are a number of places, Africa, Latin America, Europe, North America, where arbitration had to develop. It came along. It was a process that developed and became accepted in business practice. So there are a lot of questions that are asked by people. For example, you're asking, I hear it in Barbados, I hear it in Trinidad, I hear it in Jamaica, essentially which reminds me, or they remind me these questions about the same questions that were being asked when arbitration was being developed in these jurisdictions that I mentioned. And essentially, there are 3 or 4 things that need to be present. And I think from the audience and the people I met last night, they are here, at least the stakeholders are here. The judiciary is very important to this process, because if they don't buy into the process, one of the aspects of arbitration is how quickly you can resolve these issues, which also necessarily includes how quickly courts resolve court-related matters, or court-related arbitration matters, interim measures, appointing arbitrators if indeed parties are recalcitrant in doing these sorts of things. So courts need to be involved in this. In Madrid, what we did was we had this project set up where every year we would have a program involving the magistrates, the judges at all levels, and the arbitration practitioners in dialogue. And so we'd set up a conference, a 2-day, 3-day conference, whereby we would get these people together to talk about the issues, explain the issues, find out from the judges what are the questions, what are the issues that they're concerned about. And invariably, they're the same questions that I experienced when I was doing it in Africa, when I was doing it in Asia, when I was doing it in North America. They're the same questions. Essentially, are you invading my turf? What is this? How am I going to, how is this compatible? And it is very incompatible, because I reassure the judges that without you, there would be no we. And so that's the thing. The integrity of the process depends on the overseeing of the process. So the judiciary is a stakeholder that you cannot exclude. You need to communicate and interact with constantly. The business aspect of it, the users are the business people. The users are the business people in this room. If they're not convinced that this is something that enhances their balance sheets at the end of the year, they're not going to use it. So they need to be convinced that it could be used. The lawyers need to understand that it's not, you don't lose business. You enhance your practice, you enhance your offering if you have an arbitration practice. As you look around the different law firms in the Caribbean, there are not many that says, well, we have an arbitration specialty and that kind of, but you can include that. You can begin to do that. And so those, I think, are the things that need to be in place in the Caribbean as we go forward with this process. Now, capability, capacity, obviously it's there. It's there. I mean, and you know that, I know that. It's just a matter of changing the mindset slightly to include an additional discipline, and I think we could do that. Now, one of the things that jumped out at me in Barbados, as a matter of fact, as I talked about these issues, the lawyers didn't come out and say it, but it was clear that they were concerned about whether or not they would be losing income if they were to suggest that arbitration is an alternative dispute mechanism vis-a-vis litigation. And you have to reassure the lawyers that that is not the case. It's a question of developing an additional discipline within the law firm and developing the people to be able to do that. One of the reasons I teach is because I can train some of the minds. I can teach the students that to recognize what arbitration is about, and that's why I took the job. And it's a fascinating experience because I can see, I've only been there for 2 semesters now, but the enrollment for the next semester, I mean, I've had to close it off because everybody now wants to do it. And I think that's a good thing. That's a very good sign. So what I have to do now is include an additional course or 2 to accommodate these people. But that's a fantastic indication of the reception of the arbitration as a discipline. I don't know if I've helped.
Very well said, Calvin, and I think very good news.